Good evening. This is Laws 12062 Alternative Dispute Resolution. It's week 2 of Term 2 2015. Tonight we're dealing with the issue of conflict and making a start on the topic of communication skills, which will be very important for your first assessment piece. I'm pleased to see that most of you seem to have formed your groups for the first assessment piece. And what you should be doing by now is starting to learn the technology and map out a game plan for uploading your recorded video session. Most people, I assume, will be using Zoom, uploading through YouTube, and then somehow getting that recorded audio-visual session to me electronically. But you don't have to use Zoom. If you wish to use GoPro or some other technique, then please feel free to do so. I would like to see it as an audio-visual presentation. It's important that I have an opportunity to hear and see what you have to say. And just as a reminder, you come up with your own scenario and allow the parties to have their dispute in front of you, and your objective is to mediate that dispute in whichever form that you wish. I say mediate in a broad sense. If you want to run it as a conciliation, then I have no difficulty with that as well. Okay, so the reading this week is pretty light on. Compared to other subjects, you must be thinking this is wonderful, just a few pages to start with. However, let me give you a word of warning. A couple of pages may not say very much, but there's a lot to it. A bit like chess, you might be able to describe the moves in a half a page, but to actually become good at it requires, well, some practice. And that's what we need to have you start doing now. So firstly, a few comments in relation to the question of conflict. And conflict is, an understanding of conflict is probably important because it will give you some tools or some insight to allow you to be better mediators or conciliators, depending on what you wish to do. Audrey, I'll just get you to mute your microphone. Can you do that for me? Thank you. We're getting that done. We're getting close. I can do it this end if it's difficult. All right, thanks, Audrey. Yeah, that's fine. That's worked well. Thank you. So I'm going to ask now if you use your chat facility and tell me what perhaps causes poor communication. Just maybe a few words or a phrase. So you've got parties in a dispute. You believe it's as a result of poor communication. What are some of the things that might contribute to poor communication? Just a few words will be fine. Education, yes. Fear, absolutely. Lack of understanding. Personality clashes, very good. All right, so these are things that you need to identify. What about power imbalance? Is that a possibility? Might that cause poor communication? Yes, all right. What about capacity issues? If you've got someone who has mental health issues or reduced cognitive functioning, so that could be an issue as well. All right, so poor communication might be, and tension, poor performance, yes, may arise from a number of different things. Why is that important? Well, in the context of a negotiation, you might commence the proceedings on the basis that people are as they appear at first instance, but there might be more to the story. So a person may actually appear to be capable of communicating well, but have some cognitive functioning issues which might make it more difficult as well. Not wanting to be there, yes, that might contribute to poor communication as well. All right, so now I'm just going to ask you to use the chat facility to come up with a few words as to why, in times of conflict, how do people react? How do they act? Just a few words. So what can someone withdraw? Oh, okay. Angry, blame, angry, yes. Defensive, I like that word. Angry and lash out. Aggressive, irritation. Aggressive, emotional, submissive. That's a good perspective. So spiteful. These are all good words. All right, let me add a few others. And then we're going to ask, why is this important? The body language shows, yes. All right, so in times of conflict, people will show their emotion. Okay, so let's just zero in on that. You're in a mediation session and right away, bang, right at the first minute, it blows up and people get angry. What techniques are we going to use to try and deal with that situation? It might happen in your mediation. Your colleagues may make it very interesting for you by orchestrating a blow up in the first couple of seconds. Separate the parties, yes. Need to be careful, you can't actually touch them, but yes. And that can be done in a more formal sense in a what we call a shuttle mediation. Shuffle, yep. Acknowledge the anger, yes, I think that's right. You've got to acknowledge that it's there. Make both parties feel welcome and comfortable. Thank you, Anthony. So what do we do? Tea break right at the start. Yes? Set some ground rules. I like that. Something stronger, says Erin. Maybe. I'm not sure about that one, though. All right. So the point that I'm trying to make is that there will be likelihood high emotion, and you'll need to create some strategies for dealing with that in an appropriate manner. In times of conflict, people tend to avoid the issue, avoidance issues. What are we going to do if that happens? Someone is trying to avoid the issue. You're in a mediation. Maybe that avoidance manifests itself in an attempt to walk out. Walkouts are horrible. If you get a walkout, it's really tough. That's an ultimate avoidance. Steer them back to the issue. Yes, bring them back. Use your language. Try to direct the discussion to alternative subjects and then back to the issue later. That's a good way. Deflect for a while and then come back. Use your language skills, calm, confident, in control. Don't get drawn into the emotion. Ask open questions, yes. That's kind of a reframing technique as well. Okay, so just be ready for that. Perhaps agree on points to cover, understand the feelings of persons avoiding the situation, acknowledge them. These are all really good points. Okay, so sponge. Yes, John. Okay, someone's been doing their reading. Let them vent for a while. It's not a bad idea. Just let them know it's okay. You can vent. Fine. You don't have to leave. You don't have to avoid the issue. Tell us what's getting on your mind. Let's hear about it. All right, anger. If someone is really angry at the start of a mediation session, and I'm saying the start of the mediation session because that's where you tend to get these issues. People are coming in, they're very sore, they're very sensitive, and there's a potential for them to let fly and manifest what's bugging them in a very real way. So I don't want to overstate it, but in a mediation session, it can sometimes be a bit like, I suppose, the opening few seconds of a title fight. So you just got to be ready to go. Deal with them one-on-one is a thought. So anger, how do you deal with anger? Someone in your mediation session starts to blow up. What are you going to do? Okay. Then, of course, there's distrust. Tea break. Ask them why. Try to diffuse the situation. Let them run out of steam. That's a good one. Calm them down. All right. Thank you. So what we want to try to do, amongst other things as well, is maybe reduce the uncertainty. So people come into this session, they don't know what to expect. They just know that they don't like this other person. They don't know you. So try to let them know that we are working towards something which will ultimately help them, we trust, and let's take away that uncertainty and let's make something certain. Let them know that you're there to try and minimize the damage and that you're in a position where you can hopefully assist them to reduce their own pain. Just be aware sometimes people actually revel in the pain. They like the fight. They don't want it to go away. So you need to be aware of that issue as well. Focus perhaps on small issues at the start. Maybe think about ways in which they do have something in common. So maybe focus on the points of agreement, and maybe invite them to think about the overall war, if you like, and not the individual battle that they're in at the moment. So these are all issues that may be of relevance. Okay, now, other factors. What are some of the other factors that might impede the discussions throughout this process? Are there any other factors that are relevant? Reluctance to compromise, yes. Suspicion is probably more detrimental. Language, yes, that's a very important point. Lack of understanding. Cultural issues, yes. All right, so some other ones that I've written down here, perhaps are issues to do with financial factors. People may be stressed and concerned, unable to deal with the problem because they're dealing with those financial issues. Maybe people have different goals, maybe have different ways of life. One really important one, and this is what we try to do from the outset in the mediation, is try to take away perhaps the self-interest and deal with the issue of failing to focus on the other party's concerns. Very importantly, we try to work from an interest perspective rather than a principles perspective. Now, does anyone know what I mean by that? The difference between issues and dealing with them in that sense? Or interests, perhaps, is a better way of saying it. So what we want to do is have people negotiate from an from an interest-based perspective rather than a principle-based perspective. Okay, so just to take an example, someone may say, well, look, you're always doing this. It may be a neighbourhood dispute. You're always mowing at the wrong time, and I just want that finished. So interest-based is focusing on, Catherine says very, very well, interest-based is focusing on the outcome. So we're looking at the bigger picture. What's ultimately in your interest here? Rather than necessarily focusing on this small aspect of the dispute, what's the bigger picture? And try to look at their interests more than anything else. Okay, well, thank you very much for your contributions so far. What you will notice in the reading so far is that when it comes to your mediation session, I will be looking for you to demonstrate an ability to undertake some very important communication skills. So one of those skills is the ability to reframe. And reframing is described in the text at page 26. And it's essentially take what was said, capture the essence of it, and then rework it back to the person who communicated in the first place. So can anyone give me an example of reframing? When it might be traditionally useful to reframe something? It can be a specific example or just in general terms. When would you use that technique of reframing, do you think? Yes, to clarify, to try to put the other person's point of view, put the question in simple terms. Okay. When a party is showing a lot of prejudice or emotion and they're being very personal, what we try to do, acknowledge their feelings, what we try to do through that process of reframing is we detoxify the situation. So the example in the book, I think, is very good, and that is something about you're always trying to do something to avoid me using the photocopier, detoxify that, ask a question. So you need access to the photocopier to effectively perform your job. Is that correct? And very often the reframing exercise is put back in the context of a question. So you often reframe in a question. If they have a long history of friction, how would you deal with this one? In terms of reframing, yep, It's a matter of detoxifying, taking out the emotion, and trying to work towards obtaining the issues. You see, in determining a dispute, one thing you need to do is work towards identifying an agenda, and that means in some instances determining what are the important points. Now, the agenda typically will be 1 or 2 words. So it might be that after someone vents and has their say in relation to a whole range of things, that there are issues that need to be considered and dealt with. What you need to do in that process is work out how you can go about adding down a few words which will form the agenda. And sometimes reframing will allow you to do that. So when you're reframing, you're really taking what is said, you're detoxifying it, you're sending it back to them. One thing that does do is, of course, shows that you're listening very carefully. Active listening, as we call it. And Catherine identified to show listening and their point of view is important, to acknowledge their feelings, says Audrey, to demonstrate an understanding, says Forbes. So they're all very good answers. So it's important that you as the mediator show that you understand and you acknowledge and you show this is important. John, 2 ears, 1 mouth, use in that ratio. Very good. Active listening is very important. It makes the communicated words objective. That's what you're hoping to achieve. So it helps a party to understand the other side as well in what has been said. So we try to remove the emotion, express it objectively, and try to determine the true issues instead of a position. It's a great skill when speaking to clients and taking instructions, says Catherine. Yes. It is a really important thing to practice. And it's one of the things that I'd really like you to practice during this week. It might be that you're doing some reading, I don't know, just reading some. I suppose if you went on Facebook and you just read a typical Facebook page, not that I read Facebook, but what I know of it, and you'd see a lot of things that you could practice reframing. And you could say, well, that's clearly a very nasty, personal, horrible comment. If I was the mediator and that was said in a mediation, how would I immediately reframe that? Now, I don't mean to scare you, but here's the hard part. You don't have very long to do it. It's not as though you have the opportunity to say, now that's a very toxic statement that was made by that person. Allow me the opportunity to reframe that in an appropriate manner. They're not going to do that. You just have to come out straight away. So John Toppler says, reframe articles in the Courier Mail. Yes, maybe there's lots in that one as well. So find something which will allow you to practice that art of reframing, detoxifying, taking the essence of what was said and send it back in the form of a question. Usually it will be something like, so I understand that what you're saying is this is important to you. Is that correct? Things of that nature. It also allows you to take control of the room. So if you're good at reframing, immediately people will start to settle down. They'll see that you understand, you're listening very carefully, you're good at what you do because you heard the magic word, you've identified the main points, and you've repeated that back to them in a form that says to the person who said what they said, yes, you've acknowledged me, you've understood me, you've listened carefully to me, and you've taken the main point from it. So now I'm starting to gain some confidence in your ability to mediate this dispute. You know, at the end of a mediation, you should really be on very good terms with both parties. Ideally, they would both respect you and trust you and be confident in you. When I went through a mediation training course, and I've been through a few, but one in particular at QCAT, which was extremely well run, Professor Ashman, who was one of the conveners, said that by the time that you have finished the mediation, the parties should both think of you as their brand new best friend. And that's an important thing to work towards. So you've got to be outgoing, approachable, friendly, all of those things, confident, inspiring to a degree, but ultimately they should think of you in friendly terms. And then you'll really start to get a good result throughout this process. Okay.
John, could I just say something?
Yes, John.
Does it ever come to a situation when you realise you're not getting anywhere, the two parties are poles apart, and you have to actually come to the conclusion that mediation just is not going to work?
You'd never like to do that. Yes, ultimately, you know, not every mediation will conclude in a separate way, but that's a really good question. And it's off topic a bit, but it's a really good one because I want to explore that a bit more. Would you just let it go at that? And it's not just for you, John, but everyone. And please feel free to answer live or to use the chat facility. What if you do get to the stage where you think this is hopeless? Set another time. Okay, leave the door open. What else could you do? So the mediation is not, we're not going to get an agreement. It's all is lost. It's not going to work. Have some time out. Give the party some time apart to think. Ask them to come back in 15 minutes. Yes, that's a good idea. What else can we do? And this might happen in your mediation session, so you're going to have to be ready for it. You think,
maybe they need to be referred on to someone else, John.
What was that, sorry?
Maybe they need to be referred on to some other services to help.
Yes, was that you, Erin?
Yes.
Yeah, no, I think that's a good idea. And that could, so introduce a third party. Yep. Anything else? It's dying. This mediation session's going nowhere. You don't want to fail the course. Emphasise where points of agreement. Okay, that's a really good point, Forbes. Bring them back to points of agreement. Maybe reset the starting point. Okay, you've agreed that you are neighbours. You've agreed that you're both going to live there. Brainstorming ideas. I like that one, Catherine. We did that last year. You agree that you both want to have a peaceful life. So there's plenty of points of agreement. Let's see if we can think about some other options. So brainstorming is a good one. Set up individual meetings and find out where there are issues that they haven't talked about. That's a really good point, Anthony. So maybe go into private sessions with them. Invite one person to go out, take a seat for 10 minutes while you speak privately and confidentially to the other party. And then you would normally do the same for the other side. So break it up in that sense. That's a really good way of doing it as well. What about emphasising the best alternative to a negotiated agreement, the BATNA? Ask each party what they want out of the session. Yes, do some reality checking. If you don't settle this, what is the best alternative to settling the matter today? What are you going to do? What's your best alternative? Are you going to walk away? Are you going to make a complaint to someone else? Are you going to engage a lawyer? You know, try to have that party, before they walk out on you, be very clear on what they're going to do as the alternative. It might just make them stop, think, prop, and think, okay, well, maybe I should take this opportunity. Draw their attention to the cost and the emotional issues that go with court proceedings. That's excellent. And you might do this in a session together, or you might do that in the private sessions that I've talked about. If it really isn't going to get anywhere, then maybe you can draw up an agreement on the issues where there are points of agreement and issues where there are points of disagreement, and get them to sign that. So that if the matter does go to court, what we can do is have this presented essentially to a court saying, here are the issues where we agree, and here are the 3 points we disagree, and this is what we really want you to make a decision about in the court hearing. So try and identify points of agreement and points of disagreement. So I'm very pleased that you raised that. I think that was Erin. So thank you for that. All right, so reframing is an important exercise, and there are some other advantages. It may assist in making a connection. It may allow you to show yourself as being impartial, but yet supportive. It allows you to take control of the room. I think I mentioned that before. It allows a party to settle into the process. You've started to ease them into the process. And also, and this is important, it stops them from repeating things over and over again. And if you've reframed correctly, the party who's made the statement might say, essentially to themselves, okay, I don't need to repeat that. He or she's got that. I understand. She understands me now, or he understands me now. So it gives an opportunity to move forward. All right. So what is an example of a closed-ended question? Can anyone just give me a quick example of a closed-ended question? Yes, no is the response to a closed-ended question. Yes. Binary. But what's an example? Can you actually give me a closed question? None yet. A closed question. Do you want fries with that? Yes. Are you on strike for wages? Yes. These are good closed questions. How many dollars are you looking for? Now that's a bit open, because that one's not an answer yes or no. So the real test for an open or closed question is, can this be answered with a yes or no? And that's it. Okay, so that's a closed question. An open question can be a little bit open or very widely open. So the example that was given before of an open question but of a closed character was, how many dollars are you looking for? So the response is quite specific, and it's maybe in one word. A very open question, if there are degrees of openness in this regard, would be, why did you come here today? What do you wish to achieve? That's very good, Catherine. So they're sort of open questions that you might ask. In a courtroom context, in, say, criminal law, we see open and closed questions every day. And typically it's this way. When a party calls a witness to give evidence, and that party does give the evidence at the request of the party who called them, then the barrister or solicitor who is asking the questions will have to ask open-ended questions. In other words, in a criminal prosecution, the eyewitness to the alleged offence goes into the witness box, the prosecutor stands up, the prosecutor will then ask an open type question such as, where were you on the 4th of February 2015? That's an open question. What did you see on that day? Open question. Where did you go? Open question. What did you hear? Open type question. The prosecutor can't ask a closed question such as, did you see the defendant steal the item? That's a closed question because that's a yes-no response. When you're in the witness box in cross-examination, you would expect to receive lots of closed-ended questions. So the defence barrister gets up and has his or her turn and says to the witness words to the effect, you weren't at this address at the time you say, were you? That's a closed question because the answer could be yes or no. But that's okay. Closed questions are all right in cross-examination, but they're not okay in the examination in chief. Okay, so I'm off topic there, but it's an example of the open versus closed questions. So why would you use open-ended questions in a mediation session, and when would you use open-ended questions? Okay, firstly, why would you use open-ended questions if you're a mediator? To get more information. Excellent. There's got to be more than that. So you ask for more information to discover the issues. I love that word, issues. Use that a lot to get things rolling, to get the other person's point of view. Thank you. To get the parties to open up. Yes, to get to the bottom of the matter. Okay, so that's good. And that's usually these are the sorts of things that happen towards the start of the mediation session. What do they really want? Says Audrey. Yes. And open questions can continue throughout the mediation or conciliation process. Even at the end, when you're trying to encourage the parties to come to an agreement, you might be using open-ended questions such as, what do you wish to say to Joe about your concerns? And how do you believe that we can resolve this? So open-ended type questions all the way through. I have just alluded to another dynamic as well, and that is, while it's true to say at the start of the mediation, the parties may be focusing their attention on you, you do want to fairly quickly have the parties start to engage with each other so that you take yourself out of the picture a bit. That may not be possible at the start when emotions are high and there is miscommunication and there are impediments to appropriate communication and people are not respecting an agenda and they're flying all over the place. So you may need to take control of the room more so at the start, setting the agenda, identifying the appropriate issues, asking open-ended questions to elicit more information. But as the mediation session progresses, you'll then start to do more of the asking the parties to focus on each other as a way of resolving the dispute. Okay, so open-ended questions, we get information. It helps to set the agenda. It also helps to generate options. So if you're asking lots of questions, open-ended questions, people are providing information and you're picking up on clues and you're thinking, okay, so the parties in this dispute about the way in which the house was painted may be able to resolve things because the painter also does paving work, and I've just heard that the homeowner needs to have some paving done as well. So you just keep that in the back of your mind because it might just generate an option, a way to resolve the dispute in terms of getting something done between the parties which is not necessarily immediately obvious. Okay, so you try and get as much information as you can and try to zero in on an important word or a sentence or an idea or a phrase. Okay, well, you're all hanging in there very well. Sometimes you use silence as a means of extracting information. So thank you, Jenny. You've done that for me. Does it ever happen, and I've lost it, does it ever happen that one of the parties can get violent? And the answer is yes, it can happen. And that's where you need to be very careful. It sometimes need to have security measures in place. Sometimes you need to ensure that there are no domestic violence orders in place, or that you're not, in contravention of, you're not encouraging the parties to contravene a domestic violence order. Perhaps give them fair warning as well. Okay, so what I was doing there is just using a little bit of silence. It helps the parties fill the gap in, because when there's silence, people don't like it, and what they'll try to do is think, I should help fill this gap. So sometimes you can do that. If you're not seemingly getting anywhere, there are two really good techniques. One is you go the complete opposite of silence, and you use the brainstorming technique. And it might be as honest, if you like, as this. Well, I'm running out of issues, but I'm very determined to help the parties come to an agreement. So let's just take a moment to step away from the dispute for a second. Let's be as objective as we can, and let's just think about quickfire, any possible solution. It doesn't matter how silly it is. Let's just see if there's anything at all that we can put on the table that might help resolve the dispute. And brainstorm, we'll just do this for about 30 seconds. Okay, let's go. And see if people will actually start to say some words and generate some ideas. Another way of doing it is if the parties are starting to get off topic, they're starting to not abide by the rules, they're not cooperating, they're not making any ground towards resolving the dispute, then maybe you just use silence for a while, because people don't like silence and they will try to fill in the gap, and that might just help. So that in itself might help in brainstorming from a different perspective, because they then come up with an idea that nobody had thought about before. There is another thing too, and that is that it helps to transfer the ownership of the dispute to the parties. Now, that's an important concept, and keep that in mind when you're mediating. It's a little easy to think that as the mediator or the conciliator, you are, in a sense, the star of the show, and that's not the way it should be. Your role is to help the parties to resolve their dispute. Now, if you think about it, litigation is all about transferring the dispute away from the parties into the hands of the lawyers, into the hands of the judge or magistrate, as the case may be. So the parties can sometimes in a litigation feel that they've lost ownership of their own dispute. Other people have taken it and they're running with it. And that shouldn't happen. In a mediation session, I'm very keen on ensuring that you let the parties know this is their dispute and you're there to help them. It's not a cop-out, but it's allowing them to take ownership of this dispute. It's actually quite a valuable thing to have ownership of your own dispute. So keep that in mind. So sometimes silence can help to let them fill the gaps and they then regain ownership of that dispute. Active listening, we've talked about that before, and that's an important thing. Always, it does need to be practiced, and you should practice that during the week. Now, here's a technique that you need to get used to. When we talk more about the actual structure of mediations, I'll talk about setting the agenda and opening statements. But in those early stages, people are venting, they're letting their emotions run, they're firing away with lots of information. Somehow, if you put your head down and you start to write, then you're going to lose them. It's very important that you're able to maintain eye contact and use the open body language, etc. Now, it's a really difficult technique to master, but you somehow need to be able to take important notes at the same time as engaging with the parties. So just maybe practice that. How are you going to do that? Maybe one way, you could just sit watching the news, and as you're listening to a news story, you might think, well, okay, so there's a dispute in the Middle East, it's about this. How would I, if I was involved as a mediator in this dispute, how would I make sure I remember the key points, but at the same time maintaining eye contact? So sometimes you may have to practice the art of writing a word or a sentence without looking down, for example, in such a way that you can come back to it. And the idea of, and we'll talk about this more, but the idea of the opening statement is to say, okay, and these sessions are recorded, yes, John. So the idea of the opening statement would be to allow you to identify, let's say, the 3 or 4 or 5 main points which are of interest. So do you mean the mediation, John? So yes, in your mediation session, I'm sorry, thank you, Catherine, you're talking to the other John. So in the meantime, what you need to do is actively listen, learn to take minimal but relevant notes. At the same time, maintain eye contact and use non-verbal skills, open body language, etc. Now, John previously mentioned sponging, and that's a valid point, letting people vent their spleen, but be careful. It can easily get out of control, so you do need to be able to put a limit on it, and you need to do so in a way where the parties will still engage in the process and we haven't lost them. So you've still got to maintain control. All right, now as an exercise during the week, what you might want to consider is practicing your body language. And by that I mean, just a simple example, just have a chat to someone, maybe don't even tell them what you're doing, and try and engage in a dialogue. And while you're doing that, just see what happens if you sit back, don't have eye contact for a little while, maybe show relative disinterest. And then in the same conversation, if you can do it, suddenly change without necessarily telling them. Start to step forward, engage, maybe use a little bit of some body language. Make sure your arms are open, and just engage. See if they start to mirror what you're doing. Maybe they will start to use their arms. Maybe they'll be more interested in what's happening as well. So that's an important technique in mediations, in that you really need to draw people in and give them that chance. All right, so lots of things are coming through on the chat facility. I've fallen behind, I'm sorry. So now there were some questions about, are the sessions recorded? Are the mediation sessions? So mediations are generally not recorded. I don't think they're recorded. All right, no arms folded. What if one party's being so ridiculous, and even you as the mediator know that if it goes to court they'll lose, and be honest? One thing that we do have in, say, QCAT is a pure mediation session is where the mediator will not provide advice or reality check. We're in a conciliation. If you choose to go that way, the mediator or conciliator has more power to express opinions. Either way, I think it's entirely appropriate to ensure that the party at least thinks about what the options will be if they don't settle the matter during the course of that settlement. If you want to go further and say, well, this is what's going to happen or likely to happen, then that might be an issue for you to consider. Now, Robin says, I have a settlement conference and directions hearing to do, so I'll be using your suggestions as registrar. All right, well, thank you, Robin. That'll be interesting to see. Okay, I've done a lot of talking. Are there any questions before we wrap up? Because I've gone longer than I had expected to do so. Okay, thank you all for listening and participating. I'll stop the recording now,